registered US patent attorney and certified valuation analyst. Mr. Speier specializes in life sciences IP with vast experience in Hatch-Waxman cases and pharmaceutical asset valuation. He provides expertise in IP strategy advice. Welcome, sir. Next, we have Mr. Hari Subramaniam from Subramaniam and Associates joining us with a background in medicine and over 40 years in IP law. He has handled more than 45,000 patent matters. He's also played a key role in initiating mailbox applications in India and is a prominent figure in legal education. Welcome, sir. Our final speaker is Ms. Komal Shah from SML Limited. As director of SML Group, she oversees research, development, and IP in crop protection, nutrition, biologicals, and biostimulants. She's led SML to develop a global patent portfolio with over 400 applications. Welcome, ma'am. So now I'd like to hand over the session proceedings to Ms. Aditi Subramaniam for the discussion on a comparative look at India and the United States. Thank you.
Thank you very much. Ladies and gentlemen, thank you very much for staying with us so late in the day. This promises to be a thoroughly riveting discussion, so I'm glad you're all here for it. But honestly, even if it was just the four of us, I would have been delighted to do this, just the four of us. Very loosely, what we're hoping to do over the next 40 minutes is focus a little bit on patent prosecution specifically. The idea is to start with a general sense of what patent prosecution looks like today. We will go over what the changes this past year in the Indian patent prosecution scene have done to the landscape. We will then move on to hearing from Mr. Speier on his particular views on patent prosecution in the US, but also the specific interaction between patent prosecution and artificial intelligence. And I know a lot of people here have heard that phrase, that expression quite a lot today, artificial intelligence, but I promise you there is a lot of very new and interesting stuff to be learned here. We will then move on to Ms. Shah. Would you prefer Ms. Shah Bhukhanwala or just Ms. Shah, just Komal? Just a quick aside, I struggled for a little bit. I agonized before we came onto the stage on how to address my fellow panelists this evening. I'm very happy to say Gary and Komal, although they're both very senior to me, and this is not in age but in experience. And this is slightly contrary to our culture here anyway, to use first name, to be on a first name basis. But the difficulty is with Mr. Subramaniam, who is not only my boss and senior, but also my father, and I'm not sure how he'll take to my suddenly saying Harry. Anyway. Right, anyway, so let's dive in. Mr. Subramaniam, can we start with a sense of what the major changes were, in your view, in the Indian patent prosecution landscape this past year or so, with a specific focus on, for instance, the new patent amendment rules, and what you think that means for both practitioners and applicants, please?
Thank you, Aditi. I think I'll go back a little beyond what happened last year because we come from a jurisdiction where nothing really happened for nearly 100 years. And then suddenly we seem to gallop in the last few years. You know, we had this 1911 Patents Act in India. It was a Patents and Designs Act, a codified act of 1911. And when I commenced my practice in 1981, the new Patents Act of 1970 was already in force. But you'll be surprised, in 1981, 1982, I was prosecuting patent applications filed under 1911 Act, but examined under 1970 Act. So, and those were the days where the term of the patent was 16 years, and under the 1911 Act, and suddenly the new Patents Act comes into force in 1970. Actually, 1972 April it came into force, and at that time, the several subject matter were deemed unpatentable because of the socioeconomic conditions prevailing in the country after independence, and therefore, it was felt the major criteria for revamping of the Patents Act 1970 was that 1911 Act in 1970, after appointing several judicial committees to look into it, was to look at the socioeconomic conditions of the country and then see what changes need to be made. And it was felt, well, it was realized that almost 90% of the patents in India were held by foreign nationals and foreign companies, and many of them were not really used in India. That's a complete monopoly. And secondly, the India, in terms of food, medicines, and agrochemicals, were really very weak, and therefore a boost and incentive had to be given to those sectors in India. So therefore, product patent regime was cancelled completely. It was no longer possible to patent pharmaceutical products and agrochemicals and chemicals per se, even optical glass and semiconductor. And the term of the patent for these, for processes, were reduced to 7 years from the date of filing, and all other areas of technology to 14 years. And so those days, patent prosecution was easy. Patent litigation was even easier, because before you even embarked on a patent litigation, the patent prosecution wouldn't have even commenced, and the term of the patent would already have lapsed. So it would take, sometimes we would get patent grants after the effective term was over. And things changed in 1995 when we joined the WTO, and we are given 10 years moratorium to bring our patents law into consistency with the TRIPS agreement, and we are given, so we amended the Patents Act in phased manner. So in 1995, we were enabled to allow to file patent applications for pharmaceuticals and drugs without the fear of being them rejected summarily. Then in 2000, the term of the patent was increased to 20 years from the date of filing. And then 2005, the product patent regime really started. All the applications, pharmaceutical products, were examined from 2005, and patents started getting granted. And so it looked very, very exciting. And things went on very well. But what followed after that was a bit of a nightmare, because the law kept changing at such a rapid pace. We started recruiting everybody all over the world. People got excited. We used to receive 2,000 patent applications in India, suddenly it became 35,000. And then all the pharma and drug companies were very, very excited. But then we also had some dangerous provisions enacted into the Patents Act to avoid what is called evergreening. We had a specific chapter. We already had them, but there were amendments made in the Act to change to define what inventions are not patentable. Then we recruited a huge number of examiners who were all trigger happy. And we started losing a lot of patent applications to trigger-happy examiners. Then we also introduced a system of a pre-grant and a post-grant opposition, which is something unheard of in many other jurisdictions. Last year, then we had an IPAB, of course, Intellectual Property Appellate Board, which did not function well for a very, very long time, because there was always a vacancy and the government was too lethargic to appoint people there. Finally, when they did start functioning, it just got abolished. Now, in 2000 it was abolished, but in 2019 we were already aware, some of us were aware that's going to be abolished. So the Delhi High Court, the Chief Justice appointed a 4-member committee, three judicial members, and I was a non-judicial member, only non-judicial member of that committee, to create an IP division in the High Court. And everybody was excited. And the IP division was created in 2000 April, and we had a fantastic time because we had a specific IP division which was only listening to IP cases. That 2020, sorry, to 2020, yeah, 2020, beg your pardon. It worked very well, but then the bane of our judicial system started. I'm not going to say only nice things here, because some of the things have to go back to the judiciary and the policy makers. What plagues us today is enormous delays in the patent office and at the judiciary level. One of the biggest things is that today we have IP division. It started working very well, but the roster changes completely. So several times, a plaintiff is not able to get a relief as fast as they would like to. In other jurisdictions, they do get that. Judges changes, sometimes the whole proceeding starts again. And the IP divisions also seized of appeals from the patent office today. Unfortunately, in trademark appeals, probably the IP division works well, but on patent side, the judges are not very, very keen on really hearing the matters on merit, and rather keen on remanding the case back to the patent office, which means that often it goes back to the same people who examined the application. You could have had a review, you didn't want a review, want to go to the judge, but it becomes a review again, and which is terrible and causes delays in the patent system and in the whole purpose. And then the amount of time that you have to face in defending your patent, it's almost like inventor is punished. When we are creating the IP division, one of the things that I had proposed to the IP division was that when a patent revocation, application for patent revocation is filed, based on exact documents on which the pre-grant opposition was filed, the post-grant opposition filed, and the revocation is filed, there is absolutely no penalty on the defendant. Defendant would come and often file a bunch of completely irrelevant documents. The sheer size and amount of the documents before the judge, technical documents, actually scares the judge. And judge does not want to go through so many documents, and there's no accountability on the defendant. And my friend and colleague, Komal Shah, who is here, who has faced this situation, an absolutely incredible patent. You know, we had it for a silly reason. It was refused by the patent office in Mumbai. The appeal and an incredible number of pre-grant oppositions, won every one of those, won several post-grant oppositions, was review petitions and everything, and the matter is before the court today with rampant infringement. You also got some interim injunctions, but still nothing happens, and the patent is still under challenge. So I'll stop it here today because the patent system looks good, but then, you know, it's like a balloon. You press something here, something else explodes somewhere else. Today, the patent office, few years ago, patent office was delighted at the fact that, you know, they have so much of new examiners, and they promoted everybody else as controllers today. Today, we have no examinations happening at the patent office today because they have too many controllers, no examiners, too many generals, no soldiers. So we seem to be, you know, finding ourselves, digging ourselves into some deep pits somewhere or other and keep facing problem. I'll stop it here and come back to it later after others have had a chance to speak.
Thank you, sir. Yes, there are a couple more questions that I have in mind that I'd like to address to you, but this is actually a good point to segue into Mr. Speier's practice. We have a rare stroke of good fortune here to be hearing from someone who has knowledge and first-hand experience of the overlap between emerging technologies and patent prosecution. Mr. Speier is knee-deep in that intersection between artificial intelligence and the US patent system. Mr. Speier, obviously, according to the Stanford University Index, but really multiple other ranking systems, the US leads the world in terms of research and investment in AI, but also how responsibly AI is being used to prevent harm in the US. I know that the US has, for many years, far outpaced not just China, but all other jurisdictions in terms of private investment in AI. I think in 2023, private investment was in the US in artificial intelligence was close to 70 billion US dollars compared to the second closest, which was China at 7.8 billion US dollars. Obviously, that's a sizable difference. So in view of the fact that your jurisdiction has outstripped the rest of us by such a tremendous degree, my first question to you, and this is a two-parter, how is AI used in legal services today, particularly IP services, more specifically patent prosecution services, but also, and this is the second part of the question, what are the top ways that you personally are utilizing artificial intelligence in your practice as a patent prosecuting attorney?
Well, thank you. My answer is the same for both questions, but before I answer it, let me ask, with a show of hands, how many people here routinely use AI in their practice? Okay, maybe 5%, 10%. I look forward to being back here in 5 years and asking the same question and seeing the response that I get. So generally, the AI tools are broken out into two buckets. The first is what you may be more aware of, and that's the chat GPTs of the world. And this is AI that goes out to the web and obtains the information that's being requested. And when you hear of what we call hallucination, and that is the AI giving false answers, it's always going to be with tools that do that go out to the web and provide information. And sometimes the information is wholly inaccurate. We use those tools predominantly for searching. So in lieu of having third-party searching facilities, we carry out a lot of high-end searching using these tools. The better tools tend to have subscriptions, so we don't use items like the free version of ChatGPT. With these tools, I would say it's like having an army of freshers or first-year associates. You can't always rely on the results that they give you. You need to critically evaluate it. You can have 5 freshers, you can have 100 freshers, and you can give them 10 hours or 100 hours to complete a task. But I think you would be foolish to take that work product and blindly send it to your client. You need to really critically evaluate it. Of course, much like AI, the more you're able to train those individuals, the better the work product should be, right? So over time, you can expect the work product to be better. The second bucket, and these are the tools that I'm more intimately familiar with because I'm fortunate enough to work with a group that is developing such a tool solely for the IP space. This is patent drafting, prosecution, litigation, and opinion work. Now, these tools are what are called closed. So they don't go out to the web. They only work off of documents that you upload to the software. So you're not going to get hallucinations. But also, like the first bucket, it's like having a group of freshers. You know, the software programmers who develop the AI, they start off with basic, rudimentary aspects of our practice. And once you're able to teach the tool how to do those activities extremely well, then you continue to expand and make the tasks more complicated. So routine, low-hanging fruit aspects would be uploading an office action and having the tool generate a template response. Now again, this does not include the arguments, but it basically takes the contents of the office action, understands what a 102 in the United States, what a 102, what a 103, what a 112 rejection is. It captures the cited prior art, it captures the rejections made by the examiner, and puts it into a format, you know, that is conducive to start your analysis. So this is something that would have taken, you know, a person maybe an hour or two previously. Some back office is now getting generated automatically. From there, We'll have the tool start to provide the claims, the status of the claims as they exist. We will start pulling it from the file history. We then move on to more complicated aspects, with the opinion drafting, for example. We could have the tool start to analyze the cited prior art. We can have the tool start to generate claim charts. We can have the tool start to overlay the prior art based on aspects of the specification, for prospective divisionals and continuations. So I'm fortunate enough to work with a team, and this team is a group of software patent attorneys that have developed software tools in the past for the IP services to now move into AI. So hopefully that answers the question.
Thank you, sir. It does. Which really leads me quite neatly into my next question, which is, when you're, as part of a team working on developing software like this, you must be part of having a reckoning with questions over open and closed AI. So in the 1600s, when we wanted more access to scientific knowledge, we came up with the idea of scientific journals. And then in the 1970s, you have questions about open source and free software, and advocacy for open source software when programmers pushed for access to research. And the questions we're answering now are questions about whether AI technologies should be open or closed. And I'd love to hear, well, your idea, your thoughts on what the differences are between those two, because my understanding is that there isn't necessarily a consensus on what open AI means. So that's one part of the problem. But then also this other piece of the problem, which is that open may not necessarily be one concept, but more of a spectrum. So I'd love to hear your thoughts, Mr. Speier, on open and closed. The debate between the two, is one better than the other? Not just as a patent attorney, but also as someone who is part of a team that develops AI software.
Well, my personal view is closed is only working on documents that you upload, that you have control over to bring into the AI. And then open would be anything that's not closed. So anything on that spectrum that is anything other than limiting yourself to the documents that you upload would be open. My personal preference right now, considering that there is this issue of hallucination in using open AI, I always prefer, if it's a legal document, if it's a legal work product, I prefer to work under closed. Obviously, if I'm doing some searching and I want some analysis of some aspect of the prior art, it would have to be open, because there's going to be prior art out there and documents out there that I believe are relevant that I just don't know about. So in my practice, that's how I handle the two.
Thank you. Ms. Shah, sort of following on from everything Mr. Speier has just said, I know that SML Limited, as we were just talking about outside, does a great deal of work in climate smart technologies. So I'd like to shift the focus of our discussion a little bit to your areas of practice, and with specific reference to these climate smart technologies, and perhaps you could tell us a little bit more about what that means. Your experience, not just as an accomplished scientist and an IP practitioner, but as an applicant slash inventor, your experience with the Indian patent system with specific reference to these newer and emerging technologies, please.
So thanks, Aditi. Pleasure to be here today. A little shift from AI. We work in an industry which is the agri-inputs industry. Globally, this industry is to the tune of around $300 billion, right? About $250 billion comes from fertilizers, and about 60 odd would come from crop protection. Biologicals today are at about $15 odd billion, right? So while the world is trying to push towards safer, greener alternatives, which are biologicals. It's a very long and arduous process because it involves a lot of regulation, it involves a lot of R&D, it involves a lot of trialing out, and then there's also, due to climate change, there is a massive, massive impact on the way the crops are responding today. So if you look at globally, what's happening is scientists are actually stating that even though agriculture is supposed to be a carbon sink, or forests are supposed to be carbon sinks, they're not able to sequester as much carbon today because there is already an excessive pressure out in the environment, because in the last 30 or 40 years, the CO2 levels have gone up by 50% or more. So while there's so much talk and so much, we've got the Paris Treaty and all that happening, but last year we've already added more carbon as of 2024. Right, so now this puts a lot of threat and risk to the agricultural ecosystem. So food security is at question. Nutrition security is at serious question. With this kind of climate change happening, the pests and the disease of pests, I would say the spread of pests and even the infestation levels are getting out of control many a times, right? Climate change actually poses a risk, and every year there are crop losses in different parts of the world. India is no stranger to that. So is the US, so is Brazil. Brazil had the biggest drought this year, and productivity is going to drop again. So it really poses a big question. In light of such a scenario, companies are innovating, trying to develop technologies or trying to develop solutions which will address pests which are rapidly changing in the face of climate change. So in a place like India, where of course you can get a patent for a new composition, whether it's a new chemical entity or even a formulation, when it comes to methods, or if it comes to a new pest, but if it's the same composition, vis-a-vis the US, you probably wouldn't get a claim for that here in India, right? Because what you've done is you basically tested the same composition against a new pest, but that's not something that you're probably going to get protection for. It's not so easy to do, when you look at the research end, at the back end of it, it's not so easy, right? Because pests themselves are biologically changing very rapidly in the face of climate change. So it's a huge amount of pressure from an innovator's point of view to develop something and then not get any protection for it from an Indian point of view. Having said that, simple changes in the way a farmer carries out a practice, if those changes are made, can be more climate resilient. Now, if these methods are developed and they are not protected in India, it's a huge, I would say, threat to the innovator, because you get no benefit or you get no return in terms of your investment, whereas the farmer stands to lose, the ecosystem stands to lose, everyone stands to lose in the end, in that sense, because taking it down to the farmer, educating the farmer why it is climate smart, because sustainability doesn't mean anything to the farmer. He is just concerned in getting a return on whatever he's spending on, So it's a massive thing, and IP from that point of view, from an Indian patent point of view, really needs to consider that. That's all I would say from the prosecution end.
Thank you, ma'am. We have a little over 12 minutes left, so how I'd like to utilize this last bit of our time is to work in this direction, ma'am, from you towards Mr. Speier. Could we please, from the perspective of an expert scientist who is a qualified IP professional, who is an applicant and on the client side of the line, and then from a gentleman who has been called the king of patents in India, really the person to speak to for the Indian for any knowledge on the Indian patent system, and then Mr. Speier, the person to speak to on the US patent system. So really, could we, one by one, take a few minutes each to talk about best practices from your respective perspectives going forward? What do you think an applicant should keep in mind, patent practitioners in India should keep in mind, especially with view to the patent amendment rules now. And Gary, again, with a look at how AI is developing, but also more generally, what are some of the best practices that you would like to advise people? Shall we start with you, Ms. Shah, and then we'll work in this direction? Thank you.
Thanks again, Aditi. I'll speak. We shared the challenges on the prosecution front from an industry and a technology development point of view. Finally addressing climate change. But I think one really needs to take a look. I mentioned that the industry and the global agri-industry is at about, agri-inputs is at about $300 billion. But when you look at the hidden cost of agri-food systems, the FAO estimates this to be at about $10 trillion or more. So when you really look at that number, what it's telling us is that the current agri-systems are not addressing the needs, and there's a lot of losses that are actually happening because of that. You know, when we are talking about residue-free food, you're talking about metabolite-free food, you're talking about nutritious food, you're talking about hidden hunger, you're talking about malnutrition. So it's estimated that out of the $10 trillion, $7.3 trillion alone is the human health cost, right? So it's a massive, massive loss in that sense. If you look at globally, the malnutrition figures, the GDP loss is estimated to be around $1.2 trillion. It is huge. So in the light of all of that, what it's leading agri-input companies to do is rapidly innovate, because it's calling for a serious transformation of agri-input systems, food systems. With that, when you look at India and you look at litigation, IP litigation in India, and you're innovating for the future and you're trying to enforce this IP, the process does not, the IP environment or at the courts does not really consider prima facie validity of patents, when you're trying to get interim injunctions. There is a huge, huge burden at the applicant's end or the innovator's end to try to go out there and enforce the patent. And you keep coming back and revisiting the same subject over and over again. It calls for a massive, massive investment of time, effort, money to prove the same point, and for which you already have secured grants all around the world. And you're trying to actually spend more time and energy on trying to take forward these technologies, and instead of that, you're actually doing this. So it's really counterproductive, if you ask me, and that's been our experience. We also see that there's constant date changes, and the entire matter has to be heard all over again, because then you need to go back into the matter when there's a new judge at the court. Having said that, it's a massive, massive, massive effort, and it's almost, it seems like a huge challenge, just like climate change, right? I mean, are we going to understand what we're talking about in terms of prima facie validity? There's a repetition of judges taking up non-analogous prior art, even though that's been discussed in courts, and bringing it up again and again. So it places a huge burden on the innovator. Yep, thanks.
Yeah, that's a problem that I touched upon also, because it's like, in Ramayana, Sita had to go through Agni Pariksha. In India, an inventor has to go through Agni Pariksha probably for all the 20 years of the term of the patent, because there's so many challenges at every single stage. This particular case that Komal mentioned, that both she and I were involved in, he said, we faced 7 or 9, I think, pre-grant oppositions, all on exactly identical but nonsensical documents. The subject matter was a sulfur-based fertilizer, and the fertilizer has got excipients, it has particle size, it's got sulfur. So, you might as well have cited a dictionary against the specification to say that all the words in the patent specification can be found in the dictionary, and therefore the invention is obvious. Imagine how ridiculous it is. That's exactly what is called cherry picking. It was not an invention which was being challenged, but the words in the patent specification, because each word was present in some vague document somewhere else. And to go through the whole thing in a post-grant opposition, 5, 6, 7, 8 of them, and then go through the same thing in the court. And the judges keep changing, that keep arguing again and again and again over the same matter. Now, I don't think it happens anywhere else in the world like that. That's a problem. Now, we have a patents. We have been having amendments in the patents law all the time, but mostly in connection with the rules. Shift from here to the new patent amendment rules that came into force in March 15. Well, we did have some very serious deadlines in our patents law. If you missed the deadline, you lost a right completely. Now we have a provision, Rule 138 has been amended, which gives you 6 months extra extension with retrospective effect, which means that if you did not enter national phase within 31 months, or if you did not file a request for examination with the due date of 31 months, you could actually file it 6 months, up to 6 months later with retroactive thing. But the fees are huge. That's fine. But there are also some formality requirements, like filing a power of authority, filing a statement of statement undertaking on Form 3 on foreign applications, which are actually of no use for the patent office because they are all available on the internet. But if you miss those deadlines, again, you have to pay enormous fee of 50,000. We have this under the new rules today. What the patent office called ease of doing business for us. You have to file a statement of working of the patent every year under the old act. Now you can file it once in 3 years. But if you made a mistake, and which the patent office thinks that's a deliberate mistake, the penalty is 5 crores. And the way that your patent prosecution takes so much of time, 5 crores, you don't even earn from your patent sometimes. So these are the biggest bane here. On one hand, you think that our patent system doesn't cost too much in India, but by the time you end up enforcing a patent, you actually spend more money in absolutely frivolous wastage of time going to the court where the matter's never heard, and you think the matter is heard, the judge changes and the roster changes. The cost turns out to be more than the patenting cost anywhere else in the world. So I'll stop it here, and because I think there's a red alert coming on the thing in front of us, so we need to wrap up. So over to you, Gary.
Okay, I'll keep it short. So I'll just give you the bullseye of the tools that I use. On the litigation side, I do a lot of litigation. A lot of the documents that we file include a lot of, not boilerplate, but sort of template language, characterizing the patents in suit, filing date, issue date, publication date, priority date, number of claims, characterizing the claims, the assignee, a lot of information that's just very time consuming to draft. And then characterization of the prior art. I found that manually somebody has to do it. These AI tools now can do those jobs very well. Very little hallucination because the tools are at the point right now where they're trained to do a decent job. The second is on patent drafting and prosecution. We've got clients who insist on definitions in the specification of every claim term. Sometimes these sections can go 20, 30 pages long. We've now trained AI to generate this within minutes. So it's huge. It's just a very time-efficient manner. The last point I want to make, and this is truly terrifying to me, I use an AI tool that I was told can provide a psychological input to the drafter of a certain document. And I didn't believe it at first, and I was instructed to basically download a text message thread and ask the AI to serve as the role of a clinical psychiatrist and evaluate the profile of either person. And when I read the results, it was terrifying, and I thought, this is crazy. So then I went and downloaded a bunch of opinions on a certain issue from a judge who I've got a lot of familiarity with, and asked the AI to do that role as well. And the answer that came back was so spot on. I sat there thinking, what's next? I mean, this is able to do something that human beings can't even do. I couldn't do. I couldn't read an opinion and say, this judge is biased, one way or another. So Let's stay tuned. I'd love to be back here in 5 years and talk to you again about this.
Thank you, Mr. Speier. Considering the wealth of knowledge and experience on this panel, we've barely scratched the surface here, but unfortunately, this big red wrap-up is really kind of forcing us to end our discussion here. I'd like to thank the three thoroughly seasoned, absolute veterans on stage today for their time and for these insights. And I'd like to take a minute, if it's possible, to open things up to the audience for questions, if any. But you will also find us at the gala dinner or the cocktails before if you'd like to talk to any of these experts individually. Are there any questions at all? Excellent. Then we're probably the first panel today that has kept to time. Thank you very much, everybody. Thank you to Mr. Speier, Ms. Shah, Mr. Subramaniam for a thoroughly riveting discussion. I wish we had more time. Thank you very much. And thank you, all of you, for being such a lovely and engaged audience. We have 57 seconds if anyone has suddenly thought of a question they'd like to ask. All right, food it is then. Thank you very much, everyone.
Thank you very much. That was a wonderful session, the last session for the day. I'd like to call upon Ms. Aditi Subramaniam to felicitate our speakers, starting off with Mr. Gary J. Speier from Carlson, Caspers. Next, Ms. Komal Shah from SML Limited. Now I'd like to request Ms. Aditi to extend a hearty handshake to Mr. Subramaniam. Thank you very much. Please pose for a group photo to commemorate this session. Thank you very much. Now we have the last item on today's agenda. Not another session, but a very, very exciting quiz. So the topic of the quiz, as all of you may have guessed, is intellectual property. Please feel free to test your knowledge and win a 2-night stay in Udaipur or take home special mementos from our moderator. So I'd like to call upon our quiz master for the day, Mr. Ajay Mehrotra, consultant and director at Rohan